Number 111105, Douglas Castleberry v. Brian DeBrott, MD.
Your Honor, if it please the court, Stephen Day appearing on behalf of the defendant appellant in this case. I would request 3 minutes in rebuttal time.
3 minutes is granted.
This is a lawsuit that arose out of a woman in her 70s who developed wrist pain, who saw my client, Dr. DeBrott, and Dr. DeBrott diagnosed carpal tunnel syndrome. The woman, Mrs. Castleberry, later had a stroke. The claim was made by plaintiffs that signs and symptoms of the stroke were missed and that hypertension was not properly treated, and other various allegations. There was a trial. The jury decided in favor of the plaintiff, and we have appealed. Now, Your Honor, without wanting to make any argument or take up any time, since I have not had an opportunity to respond in writing, I do want to state our position on the question of whether we have raised issues that were not contained within the petition for review. I'll tell you what our thinking was, and if it's not adequate for the court, we respectfully accept that. In introducing our issues, we specifically stated that although defendants believe that all of the issues raised in this appeal should be considered, the following particularly merit review, and then we discussed the three in particular. We believe, consistent with the rule, that that is sufficient to constitute a statement as to our belief that all of the decisions were erroneous and that the court should consider all issues on appeal. If we are wrong in that regard, the major issues we want to talk about are the ones that we raised, but I do want to state that position so we have it of record.
So we can agree that the only place you think you pull in those other two issues is in that sort of introductory sentence that says...
I agree, Your Honor. I think
so you don't actually allege anywhere in the petition for review that the Court of Appeal erroneously decided those two issues.
No,
Do you agree?
My interpretation, which may have been wrong, was that that was not language of art, that the purpose was to advise as to what issues we were seeking review. But in any case, that was what occurred. Now, moving into the issues that were briefed and are clearly before the court, I want to start off by discussing the causation issue. And since the court, I know, has read the briefs and is aware of the issue, I'm going to try to just sort of dive into things. And I think there is a conversation that's been going on, which is the wrong conversation in this case, which has been a lot of talk about the fact that there are opinions of this court and opinions of the Court of Appeals, many of them since the Pick instructions, some before the Pick instructions, that use this language, caused or contributed, in describing fault or in describing causation. There is nothing inherently wrong with a court using that language as a shorthand description of causation in an opinion that is for a legal audience that knows that you're talking about proximate cause. The fact that that language is used in legal opinions does not, however, mean that it is appropriate in instructing the jury. And this court has, in fact, repeatedly said the fact that there's language in judicial opinions does not mean that that language necessarily makes for an appropriate jury instruction. So I think we have to start off by saying, what is it that a jury would have, or what were we asking the jury to decide? I think that's the first question. And we're asking the jury to decide on the issue of causation quite clearly, whether or not the actions of whether without the actions of the defendant, but for those actions, the harm would not have occurred. The court's been very specific on that in recent decisions and has applied the but-for standard fairly strictly. The most recent statement I found was in the Russell versus May case, where at pages 660 to 61, it states, to prove cause in fact, a plaintiff must submit sufficient evidence from which a jury could conclude that more likely than not for the defendant's conduct, the plaintiff's injuries would not have occurred or would have been less severe, but for causation. So we come down and we go to pick 10501, which is the instruction that was used in this case, the only instruction that was used in this case to instruct as to causation. And the question becomes, does that instruction adequately instruct the jury as to the requirement of causation? Is there a requirement of cause? We made, in a couple of different places in the records, I think, good solid objections explaining what our position was. And our position is that it does not. And yes, it's been around for a long time. I don't think anyone's ever made this argument before, so near as I can tell. So I think it may actually qualify as an issue of first impression, but certainly it has been around a long time, and I recognize that.
Let me give you a chance to, here's what's bugging me, so if you address this with that issue. Yeah, it says in the one instruction, caused or contributed to. But in 3 other places in the instructions, it just uses the word caused by defendant. And so I'm trying to figure out whether the jury really gets a sort of a head fake here, the way you're concerned about. Because 3 other times in the instructions, it specifically talks about caused by defendant. First one is in instruction 11, which is your defense description, and it specifically says that the defendant denies that any act or omission on his part was the cause of plaintiff's injuries. And then when you get to the damages instructions, it says only assess the damages caused by defendant. And it says that twice. So I'm just trying to, we get all hung up about jurors seizing on one part of instructions, but it seems to me that the other instructions would cause them to not get misled the way you're concerned about, even assuming it's misleading.
Your Honor, I don't know that this is solely an issue of misleading, as this is the specific charge to the jury in terms of what they need to find in order for there to be liability, that there is fault if the negligence caused or contributed to the outcome. The fact that in our contention instruction we said we don't think we caused the damages is not an instruction by the court that what has to be proven in order for them to recover under the critical element of causation. I don't think there's any question. The only definition of causation that appears is the one that appears in the comparative fault instruction. And
Mr. Day,
yes.
I'm sure you're familiar with the expression that a good lawyer can argue both sides of any issue, right? It's rare that we give someone an opportunity to do it in back-to-back cases in front of us, but that's pretty much what's happening here. I'm sure you appreciate, because you're in essence, your response to my colleague is that this error is so bad that just having it right or having things in other instructions that suggest the correct course for the jury is not enough to fix it.
Well,
Is that pretty much the size of it?
I think so, but Your Honor, I think there's a fundamental difference, and I don't want to talk about the last case in this case, but I think the claim there was that additional instruction would have confused the jury in terms of what was unquestionably a correct instruction of the duty of the defendant. Here we have an instruction regarding the basic elements of liability that is wrong. And I don't think that that same issue applies.
It's not just a conflict problem. Like it was.
I think it goes to the basic definition of what my client had to be responsible for, of how a finding could be entered against the defendant. That the jury had to find 2 things: the departure from the standard of care and that it was the proximate cause of the injury. And the only definition of that proximate cause that appears anywhere is in this instruction that we're discussing.
And it's wrong, in your view.
And we believe that it is prejudicially wrong, and that, I almost hate to talk about it because I know you've read the briefs, but we've got, it says caused or contributed. That's a disjunctive. That means or. It can be either one. That means contribute. And contribute does not in any way suggest a requirement of but-for causation, which is the essential element of the tort,
Right.
or a essential element of the tort.
Can we talk about the evidence and what the case was really about, and harmlessness on this particular issue? Justice Files asked you about kind of whether other instructions sort of cured it as a legal matter. I want to talk just about evidence, about the practicalities.
Yes, ma'am.
Could we talk about that? What's your
Of
view
course.
on that? On harmlessness
Okay,
of
Your
the
Honor,
error.
I think one of the important things is, I can understand where someone can look at this and say, well, the issue here was whether or not if he diagnosed a stroke, he could have prevented the stroke, and the causation doesn't seem like a big issue.
Because the link between the failure to
Right. No,
detect
I know
the
where
clot and
I know
that
where-
was well established. Nobody really argued about that.
I know where you're coming from, but that is not true of some of the critical issues in the case. And yet when you read this transcript, you find out even though it's disappeared from plaintiff's arguments and briefing, a huge part of the claims at trial involved other issues. It involved a claim that we didn't properly respond to a high blood pressure reading. It involved a claim that we didn't give an aspirin, which might have prevented the stroke. And as to both of those things, causation was a huge issue. I mean, as to the blood pressure, you had a hypertension that reading that was in the too high, but not in the critical, it's going to cause a hemorrhagic stroke range. And she didn't have a hemorrhagic
Right,
stroke.
exactly.
So she had a plaque-related stroke. And you have the testimony from our expert that plaque takes years to build up, and this little period of time we're talking about would not be relevant to that. You have the testimony of the plaintiff's expert who says that caused or contributed to the outcome in this case, and that was at least 40% of what they were arguing, I think, during this case. The same thing with the aspirin in terms of the studies indicating that it probably didn't make any difference. And I don't think we can just assume that the jury didn't decide the case on the basis of that, which was a major argument in the case. And I think you can see here how this is critical. If you are, the analogy that I threw out about you can pour a cup of coffee into a rising lake and that contributes to the flood, but it doesn't say but for that it would not have occurred. And counsel got on that about the cup of coffee and the size of it and made an argument about legal causation, which doesn't really apply in this situation that deals with remoteness of conduct. But the same issue would be if it was 2,500 barrels of water. It would still leave the question of it doesn't establish the but-for element of the thing. And we put it in this situation with the blood pressure. It is very easy for it to see a jury with that very small requirement of contribution to say that we think that this, the plaintiff's expert said it was connected. It may have contributed, and that may be the basis upon which the jury returned the verdict. And I know in cases in which there's an improper argument allowed to go to the jury, that there's a presumption that recognized in the case law that the jury acted on that basis. I think that there needs to be at least a presumption or an acceptance of the potential that this was based upon that very substantial argument regarding blood pressure as opposed to the other item, because otherwise how could you ever review anything if you could say, well, maybe that wasn't the basis on which they decided. So, I mean, that would be our response on that issue.
I thought you in your closing argument, minimized the causation issue when you conceded that the carotid duplex study, if it had been done, would have shown the stenosis, the blockage, and would have prevented the stroke. It seemed to me you just kind of gave away causation and said, and stuck with standard of care.
Well, and we didn't have a good causation argument as to whether or not if you did the test, whether it would have shown it, and then whether or not it could have been treated. But again, that's only one of the issues in this case. It's the only one plaintiff's talking about now, but it wasn't the only one they talked about at trial. At trial, I think if you look through the transcript, you'll find their experts, maybe 40% of the time, that's a rough estimate, was spent talking about blood pressure. And that's a totally different issue in terms of cause and effect. And if the jury based their decision on that, if they accepted our arguments that no, under the circumstances, it was reasonable Because we had a pretty strong case, I thought, that it was reasonable, given that he had an orthopedic surgeon agreeing with this diagnosis of carpal tunnel, that he didn't need to run a bunch of additional tests on something else. And if a jury said, yeah, I buy that, but this blood pressure thing, he was 170, whatever it was, and and maybe that contributed to it. I mean, I think you have to, that's a real potential in this case, and a situation in which this would in fact become prejudicial, even if you apply just the standard level of scrutiny, which I don't think would be appropriate given the nature of the claim as we discussed in our brief. And I've used up my time.
Let me ask you about the court's rejection of your proximate cause proposed instruction.
Yes.
I did have a problem with the way you proposed your instructions, because you have the proximate cause language there, but then I don't see where it tells the jury what to do with the information that you've just given them. How do you think they connect the dots?
Well,
Since I don't think you can disagree with me as to whether you signaled how to do that, but explain.
no, I
that to
understand,
me.
Your Honor. I think if the court gives the proximate cause language, then the definition of fault has to be modified to say cause, and the cause is consistent with the instruction whatever, which has the proximate cause language in it. The court rejected the proximate cause. The court rejected the contribution, so we didn't get into a complaint, so we didn't get into that. But anything else, Your Honor?
We've taken a lot of your time. Do you need 30 seconds to wrap up, or do you think you've made your points?
I would simply note that on the, we've talked about the reptile litigation thing, so I guess I've sort of had my chance to talk about that. I would like to quickly note, though, that when a lawyer tells a jury that it's basically, that in reaching their verdict, they need to do so on the basis of whether they want safe medicine or unsafe medicine. That is a statement that they should decide the case on an improper basis. And the Court of Appeals, as is true in case after case after case, said, well, there's just one comment in the middle of a long trial. It didn't make any difference. But it wasn't just one comment. It was the linchpin. It was the third element under the reptile theory, the one that leads to improper conduct of stating.
Counsel, given that's your position, was the Court of Appeals right when it said that you did not preserve the argument that you let multiple instances of this, what you call linchpin, come in without objection?
I think you have to make a clean distinction. Counsel's tried to put these two issues together, but there's a different issue between the improper jury instruction versus the issue of whether
But just, I'm sorry to interrupt, but just right to the point. The Court of Appeals said, correct me if I'm wrong, that at trial, this objection to the reptilian strategy was not preserved. Because while there are several objections, the Court of Appeals referred to a plethora of, or multiple instances when there was no objection.
there is an issue as to whether or not the third argument that the court should not have allowed in things like erring on the safe side in some of those statements, whether or not I adequately preserved it. I believe that under the purpose of that we met the purpose of the contemporaneous objection requirement by making the objection several times before we got into it. But even if the court concludes that that was not preserved, that doesn't change this second argument that that it was improper for
The argument with respect to the attorney's comments.
right, which and the reptile thing is still relevant for that because you have to look at the whole record to determine whether or not we were prejudiced. Anything further?
See nothing. Thank you, counsel.
May it please the court, Jonathan Sternberg, and I represent the appellees in this case. Your Honors, the court should affirm the Court of Appeals decision that affirmed the district court's judgment. The jury's verdict was amply supported by substantial evidence, which I'll note the defendant throughout this appeal not once has viewed the facts in the light most favorable to the jury's verdict. and none of the defendant's only 3 issues on review have any merit. And as he did, I'd like to begin with his notion that when instructing the jury on how to determine fault, it couldn't as a matter of law, he said below at least, couldn't be told that the defendant was at fault if his negligence caused or contributed to Mrs. Castleberry's death. He says the language "or contributed" was improper. Now, I'll note in the trial court, he only argued that this was so. This is Record Volume 42, pages 149 and 155. He only argued this was so because he said, quote, "It implies to the jury that any slight connection is adequate, and that's simply not the law." Now, perhaps realizing that is the law of negligence causation in Kansas, he switches tunes, and for the first time, what his actual argument in his briefs is a statutory argument, that the wrongful death statute, 60-1901, virtually unchanged since its inception in 1859, limits causation where the defendant's negligence killed the victim rather than simply injuring her to situations where that negligence caused her death without any notion of contribution. Your Honors, simply put, this is nonsense, absolute nonsense. I appreciate that it occasionally does happen, that there's some old statute or constitutional provision, and somewhere along this way, this court in interpreting it, or the Court of Appeals, went awry, and then later the court has to reverse course and correct itself. But that's not what the defendant is arguing here. What he's arguing for is a wholesale change to Kansas's basic standards of causation in negligence cases, unheard of in 160 years of wrongful death jurisprudence. In fact, he's asking for a wholesale change to negligence causation unheard of anywhere in the English-speaking world. But for causation is what the jury at common law, under the wrongful death statute in 1859 and today, as this court consistently has held, but for causation, which is what the jury is tasked with determining, is any cause, and I'll use the defendant's own language he used to your honors, but for the defendant's negligence, the victim would not have been injured. That's any action by the defendant, any negligence by the defendant, of course, that caused or contributed to cause the victim's injury. Now, what he's saying is, and this is this example of this cup of coffee being poured into a lake to cause a flood. Well, unfortunately, the but-for it is a but-for causation, is if, but for the cup of coffee, well, it fails but for. Let's say he uses now 2,500 barrels of water. I don't know how big this lake is. The hypothetical is getting a little out of whack. But that could be a but-for causation. The question, though, that he's concerned about is legal cause. Kansas uses some odd terminology when you look at federal jurisprudence and jurisprudence from other states. Kansas says causation is proximate cause, and we're going to divide that into but-for and legal cause. Classically, in English common law, as in the older Kansas cases, starting with the Rice case in 1872, which is the first case from this court to explore these principles, the older cases said you had causation in fact, which we now call but-for cause, and on the other side, proximate cause, which is legal causation. The first is a factual question for the jury. But for the defendant's negligence, would the victim have been injured? And the second part is a legal question for the court. If his concern was that the causes or the actions we allege caused or contributed to cause my client's wife's death were not sufficiently proximate, were not sufficiently foreseeable, that's a legal question for the court. He could have moved for a directed verdict to that end. He could have moved, failing that, for JNOV. And when that failed, he could have brought that up on an appeal and made that argument.
Counsel.
Why can't he make that argument? Why doesn't he make it? Because he fails to view the facts in a light most favorable, because viewing the facts in a light most favorable to the jury's verdict, there was ample evidence, because this is a sufficiency of the evidence issue at that point, there was ample evidence that his actions caused or contributed to cause to my client's death, and that this was foreseeable. So let's
Counsel, let me
yes.
interrupt. The last case, you wanted us to look at these jury instructions as a lay person would do that. So let's do that in this case.
Happy to.
We've got one defendant that the jury has to deal with in this case, and we've got the phrase "cause or contributed to." Now, how does a lay jury not read the "or" as a conjunction that gives it caused or something else, whatever that is, and contributed to when there's only one defendant. It seems like contributed to has to mean something different than caused. And I can understand why contributed to gets used when you got more than one defendant there. But when you only got one, why isn't this error?
I'm happy to address that concern, Your Honor. It is a disjunctive, and it has to be a disjunctive, because cause, so starting in 1872, the first time this court ever, which was obviously long before comparative fault, and in fact it wasn't even a contributory negligence case, the court said, it is only such negligence as caused or contributed to the injury complained of that makes the defendant liable. Okay, so starting with the premise that this is a correct statement of law, and he doesn't seem to disagree that this is not a correct statement of law, the jury is not instructed improperly. It has nothing to do with comparative fault. It has to do with what is but-for causation. What but-for causation is any cause, any negligence that caused or contributed to the injury. Now, if the contribution is too small, if the contribution is the cup of coffee into the lake rather than failing to take the basic safety step of listening to someone's carotid artery when they're having numbness in their left arm and blurred vision and psychological problems, if it's the cup of coffee into the lake, that's a legal question, and he can bring that up as a legal question. But the jury is not confused. The jury is correctly instructed on the law that if his negligence contributed, it's a but-for causation. But for his negligence, it would not have occurred. Okay? And this court has repeated this in countless cases not involving comparative fault. I have a long discussion of cases in our supplemental brief, 12 cases, pages 14 to 16. Hardly any of them involve comparative fault. Many of them predate comparative fault and don't involve contributory negligence either. And all of them say that the jury has to be instructed, even when it's a single defendant, even when there's no comparative fault alleged against the plaintiff, that the party, the defendant, is at fault when he is negligence and his negligence caused or contributed. What I think is so interesting here is the defendant, sure, it's a case of first impression. No one's ever thought to make this argument before because it flies in the face of the law. The law is that but-for causation is a cause that contributed to the injury. If it's too small to be proximate cause, if it's too small to be what Kansas calls legal cause, then he can argue that as a matter of law to the judge. So let's view the facts in a light most favorable to the jury's verdict, because he fails to do that. Over the course of months in 2007, Mrs. Castleberry presented at the defendant's clinic with high blood pressure, numbness, headaches, stress, joint pain, blurred vision, and fatigue. Her symptoms worsened after a fall at home, and this led her to believe on her own research she was at risk of a stroke. He diagnosed carpal tunnel syndrome. The carpal tunnel treatment didn't do anything, and then she presents on December 19th, 2007 with her highest blood pressure reading ever, swelling, numbness, tingling on her left side. I'm not a doctor. When I started reading the transcript, the first thing I thought was stroke. Blurred vision, psychological symptoms. Medical experts testified that the standard of care required the defendant at that point to suspect an impending stroke, recheck her blood pressure, and listen for carotid bruits, that is, listening for blockages in the carotid artery. But the defendant did nothing. In fact, he did worse than nothing. He directly told Mrs. Castleberry she was not at risk of a stroke and advised her to, quote, go Christmas shopping. Sure enough, what happened the very next day? She had a paralyzing stroke from which she ultimately succumbed. The jury found that the defendant's negligence caused her death. It was both a but-for cause, there was more than sufficient evidence of it. It caused or contributed to cause her death. You can think of contribution as there being lots of contributions. The fact that Mrs. Castleberry was alive was a contribution to her death. The fact that she had the pre-existing medical problems was a contribution to her death. The question, though, is whether the defendant contributed to that and whether it was foreseeable that his contribution caused her death. The jury found it was, and he didn't say that as a matter of law, as a directed verdict or JNOV, that you can't have that. Now instead, he wants to argue to this court that 160, nonsense, 200, 300 years of negligence law are wrong, that a contribution isn't enough. There has to be some kind of direct cause. That is not the law of Kansas. It is not the law of the United States. It is not the law of the English-speaking world. So for this reason, Every single Kansas case ever to have examined how the jury is to be instructed on this has held in both ordinary and wrongful death negligence cases, and for over 140 years, that just as PIC 10501 states, just as the district court did in Instruction 12 here, the defendant is at fault if his negligence caused or contributed to the victim's injury. In fact, Your Honors, I agree that there is one problem with PIC 10501, and if the court is willing, I'd like it to ask the PIC committee to make one change to that. PIC 10501 says that it should be issued in every comparative fault case. It should be issued in every case, in every negligence case. In fact, in every case that there is about fault. And I don't want to suggest that one state does something better than another, but I was, when preparing for this, I'm from Missouri, and I was examining what the Missouri approved instructions do with this. They instruct that in every single tort case, that as one element in what we call the verdict director, that's our version of a 11601 instruction. In every single tort case in the verdict director, there has to be this exact same language, that the defendant's negligence caused or contributed to cause, or the defendant's action, if it's an intentional tort, the victim's injury. So PIC 10501, I don't know why Kansas doesn't, or the PIC committee doesn't think that in non-comparative fault cases, people should be instructed on this. But here, notably, it was the defendant who asked that the jury be instructed on fault. And my clients agreed with that. I mean, we both sides agreed that the definition of fault should be given. He simply argued that it shouldn't be what PIC 10501 says. PIC 10501 doesn't originate from comparative fault cases. It originates from the common law of all negligence cases, even predating comparative fault. I'd like to move briefly to the other issue that was discussed, since I agree with my opposing counsel. We discussed plenty about safety and reptiles and whatnot in the previous case. He said that we tried to put the two issues together, that is his second and third issues. His second one being this statement, which he says is the jury will have to decide whether you have safe or unsafe medicine. But I'd actually like to read to the court what my trial counsel actually said. The real quote is, "That's 21 reasons that Dr. DeBrott failed to adhere to the standard of care. Now, in addition, the addition of a second type of blood pressure medication would have altered the odds of a stroke occurring. The odds would have been reduced. And when we establish standards of care in this case, as a jury, you'll want to decide if you want safe or unsafe medicine." He wasn't referring to the jury being the arbiters for all of Sedgwick County or all of Wichita or all of the state of Kansas, that they were going to be the arbiters of safe or unsafe medicine. He meant in this case that, as the Court of Appeals correctly pointed out, and I counted the number of instances where Dr. Miser, our main expert, testified about erring on the side of safety and not needlessly endangering the patient. It was 28 times that he testified to that without objection. 28 times in the record. And the only objections the defendant ever made were as to the form of questions, most of which the trial court sustained. And that's detailed in both our Appellee's brief in the Court of Appeals and our response to his supplemental brief here. I've linked these two issues because they are linked. The function of closing argument is to comment on and draw inferences to the jury from the evidence. Well, the evidence here, entered without objection, was that erring on the side of patient safety and not needlessly endangering the patient, and specifically the defendant's actions that failed to meet those standards, were negligence. They failed the standard of care. It's not an abuse of discretion. It's not something that a reasonable mind couldn't agree with, that in making the actual comment that Mr. Wall, the trial counsel, did, he was trying to tell the jury that, making a conscience of the community argument. Instead, he's commenting on, in this case, you'll want to decide on whether you're going to allow Dr. DeBrott to practice safe or unsafe medicine. And given what the evidence was that was admitted without objection, that's not an abuse of discretion. I think it's interesting that in his briefs, my opposing counsel rarely ever mentions the standard of appellate review, and when he does, always insists it's unlimited review. The notion that there's unlimited review of what a lack of limitation on closing argument, that's ridiculous. It's reviewed under the third prong of abuse of discretion, which is what reasonable minds would find.
Counsel, I wanted to ask you, but this goes to the admission of the expert testimony on,
Yes, Your Honor.
on the safety issue.
Yes, Your Honor.
The Court of Appeals viewed this as an abuse of discretion on the admission of evidence, and I guess I paused as I read the opinion that it didn't go into a relevance analysis. And I know you'll say it's relevant, so I'm not asking that question. I'm asking whether it was error for the Court of Appeals to skip over relevance before looking deeper into the issue.
By which you mean whether...
Whether the, this is an admission of evidence kind of question.
Sure.
And so why isn't the first question asked whether this evidence is relevant to the issues in the case?
Well, it certainly was relevant, so I'm not going to
I
say...
know you're going to say that. I'm trying to figure out whether
the
the Court of
court-
Appeals took the correct standard of review by just looking at abuse of discretion.
Well, okay, abuse of discretion is always the standard for evidentiary admissions or exclusions. This court clarified in the Ward and Gonzalez cases a few years ago that there are 4 prongs, or 4 different types, if you will, of abuse of discretion, and I think parties often tend to abuse that.
Counselor, there's no discretion to admit irrelevant
Sure, but
evidence, is
that's
there?
what I'm getting at. That much is reviewed unlimited, whether the evidence is relevant or not. However, deference is still accorded to the district court's determination that it was relevant. Here, I think the real problem the Court of Appeals had, the reason...
On the probity prong, materiality prong of relevance
is unlimited for this court, certainly. You are correct, Your Honor. But there still is an element of deference for it. But I think the reason the Court of Appeals didn't get to that was, well, first of all, it found it did go to the standard of care, and so therefore it's relevant. But it found that the defendant didn't object on this basis. There still has to be an objection. If you want to say evidence is irrelevant, that's a standard objection. Right? Objection, Your Honor, this evidence is irrelevant. It has nothing to do with the standard of care. Obviously, he didn't object to that, partly because he understood that it did have to go. Again, and I hate to beat a dead horse, but I'll say one thing that I did say in the previous argument, because I think it bears on this too, which is the standard of care is a question of fact. It's something, the court has no place in determining whether something is not part of the standard of care, because we're not doctors. We all chose not to go to med school. We all chose to go to law school. And it's up to the physicians, the physician experts, to determine what the standard of care is. And if it involves erring on the side of patient safety, it does from their perspective. And the defendant can bring up his own expert if he's willing to say that a physician, that's not part of a standard of care. Seeing I'm out of time, we'd ask the court to affirm.
Any further questions? Thank you, counsel.
Thank you, Your Honors.
If it pleases the court, the causation issue, I'm troubled by the reference to this being a legal cause issue. It isn't. It's a question of whether or not the jury was adequately instructed on but-for causation, and that's what we keep coming back to. I challenged counsel's statement, I don't have the cases in front of me, that the court has always said instruct with cause or contribute language. The original Pick instruction before comparative fault was adopted had a traditional definition of proximate cause. I think the distinction is, again, the use of that shorthand, caused or contributed in judicial opinions, is a different issue than how a jury should be instructed. In instructing the jury, the issue becomes, does that use of the word contribute advise the jury of the critical element of causation, which is but for, and it doesn't.
Why doesn't it?
It doesn't because a jury can find that that conduct contributed to an event without finding that but for that conduct.
How is that logically consistent is my question. Because if it contributed, isn't it also a but-for cause?
I don't think so, Your Honor. I think caused arguably is but for, but then you have this lesser thing.
How can something contribute to something else but not be a but-for cause?
Well, I'm going to use the same example because of limited time. If you add additional water that becomes part of the water that causes a flood, you have contributed under the ordinary meaning of that language to the flood. But that does not establish that the flood would not have occurred but for the adding of that water. If you're talking about blood pressure, you can say this contributed to, the jury could have concluded that this contributed to the level of arterial sclerosis over a couple of weeks, even without.
By contribute, so you're using the word contribute to mean made the injury worse. In other words, the flood would have happened, and all the cup of coffee did is make it worse. It
may not have made it worse, but it contributed to the, one of the things
right.
that was
in a very minute way,
Made it
it
slightly
made it
more
worse.
likely.
Right, yeah. I think, you also need to look at the dictionary definitions that we set them out. A definition of caused is you brought about the event. That implies but for. The definition of contribute is it had a part in the outcome.
Yeah, I think we're going back and forth between two understandings of the word contribute. Your opposing counsel said, look, lots of things can contribute. The plaintiff's age, her lifestyle habits, the fact that she had a fall, et cetera, et cetera, et cetera. They could have all contributed. And that doesn't defeat the but-for causation of the alleged negligence.
It doesn't, but they have to establish that the negligent act was a but-for cause of the event, which means that they have to establish, and the jury has to decide from the evidence, and be told that they have to decide that they find that this negative event would not have occurred but for the defendant's conduct. Sure, there are lots of other things that play in here, and that's the issue where the Court of Appeals got off on, in the other case we'll be talking about, got off on the issue of comparative fault and suggested that we were saying that there could be only one party at fault. No, there could be, you're comparing fault. Fault is negligence plus causation. Step one is to establish that on the defendant, and that causation step is but for. And I just have to stand by our firm belief that that you cannot say that the word contribute communicates to a lay jury the but for requirement.
Counsel, let me approach this using a historic example. I think most people have heard the expression, the straw that broke the camel's back.
Yes, sir.
Under this scenario, I'd like your view. If you have a perfectly healthy camel and it is loaded with straw, and someone stumbles and the straw in their hand fell on the camel and the camel fell and broke its leg, is that but for negligence by the person who stumbled?
It is but for negligence if it can be established that the event would not have occurred without that extra straw being added. On the other hand, if there was a straw added earlier and then you have a bunch of additional straw stuck on top, that one straw may have contributed, but it does not establish but for, which is what we're dealing with here. There's a circumstance in which you could claim that the treatment of how he handled or responded to the blood pressure might in some way have contributed a little bit, but there's nothing that would allow a jury to conclude that but for that, it wouldn't have occurred. Or even if there were something that would allow a jury to reach that, the jury hasn't been told that that's how they make the decision. And I think that's a fundamental constitutional right to have the jury make the decision on causation based upon the central finding, which is but for causation, which this instruction doesn't communicate to them.
So in the example that I gave of the camel, that was a contribution, but was also a but for.
Under the circumstances
Is that what you're telling me?
I am telling you that if in fact that straw was added and that straw is what did it, then at that point, and it wouldn't have happened without it because of that, then that would be but for.
All right, thank you.
Okay. Thank you.
No further presentation? Do we have any further questions? Thank you, counsel. Thank you both for your arguments this morning. Clerk will take this matter under advisement.